I'm Drew Stevenson, and this is a lecture from my professional responsibility class about conflicts involving materially adverse interests. This is really about an ABA formal ethics opinion that came out in the first week of February 2021, opinion 497. What I like about this opinion is that it really clarifies a point that's left a little unclear in the model rules, specifically Rule 1.9 and 1.18 about conflicts of interest, and gives some great examples. So it's very useful for teaching the concept or clarifying the concept for my students. So having said that, let's move into the points that are made here. So first, Rules 1.9a and 1.18c cover conflicts of interest for current clients with interests that are materially adverse to the interests of a former or prospective client on the same or substantially related matter. But neither rule specifies what counts as materially adverse. And so we have a number of ambiguous provisions throughout the model rules about what counts as substantially or reasonable or materially. And here we're talking about two situations. We have two rules. One is about your former client, somebody you don't represent anymore. Maybe you represented them 10 years ago. And the other is about what we call prospective clients. So these are people that come in for a consultation or maybe multiple consultations. And sometimes you realize right away that you're not interested in the case, and so you decline the representation. Other times you consider it and you tell the client how much your fees are, and then the client thinks about it and decides not to hire you or to hire another lawyer. Or you're all ready to proceed with the representation and you do a conflicts check and realize you have a conflict of interest, and so you decline the representation. Under 1.18, you still have some duties to that person, especially about the confidential information that they may have shared during the consultation, or if they brought in sensitive documents and gave them to you to take a look at in deciding whether to take the case or how much the case was going to cost, the representation was going to cost. So we have some situations like that, and then we have this question of materially adverse, and what does that mean? And that occurs in each of these rules, and this ethics opinion is trying to clarify that for us. So first, it tells us some things that are the clear cases, clearly almost always going to be materially adverse. Negotiating or litigating against a former client or someone who came in for consultations on the same or closely related matter. So a person comes in and says, I want to divorce my spouse, and you talk about it, and when you get to the section about where the part of the conversation about fees, they get up and leave, or you decide that you just don't like this person and don't want to represent them or don't have time, and then you want to turn around and represent the other spouse in the same matter. You can't do that, right? You'll probably be disqualified. That would be grounds for disqualification. And the same is true with former clients, suing a former client, trying to switch sides in the case, or as it puts it in the ABA opinion, you move to the other side of the V in the caption of the case. That's off limits. But this also applies to transactional work. So if the client is buying or selling a business or a piece of real estate or something like that, and there's another party, who's the opposing party in the transaction, your client's the buyer, they're the seller, or vice versa, and switching sides on the same matter or substantially related matter is prohibited and is unethical under the model rules, and it creates a conflict of interest. Now I'm going to give you an example, a kind of textbook example of one that wouldn't apply. So let's say you have a lawyer who represents a teenager on a minor in possession charge. So this is someone who's a high schooler, they get caught with alcohol, and they're charged with being a minor in possession of alcohol. The years go by, the representation ends, and the high schooler, the client, goes to college, goes to law school, takes the bar, becomes a lawyer, and is now practicing. And so 10 years have gone by, and now someone comes to the same lawyer and wants to sue that other person for legal malpractice, the former client. Can you do that? Yes, you can. Why? Because it has nothing to do with the minor in possession charge from when that lawyer who's now going to be the opposing party was in high school. So it's very unlikely that there's any confidential information that you're going to use or would be relevant to this new case because of the passage of time and how different the matters are, unrelated the matters are, right? So in a legal malpractice action, we're going to be talking about what was the duty of care and did the lawyer's malpractice actually cause the harm to the client? Can the client show damages and so forth? So all of that's pretty unrelated to what that lawyer might have done or not done when they were in high school. Also, a clear case of material adversity or adverseness, as the ABA likes to call it, is attacking your own work, the work that you did for a former client. So you drafted a lease and now you're challenging the same lease on behalf of a tenant. You drafted a covenant, a restrictive covenant on a piece of property for one client, and now you're representing another client trying to negotiate for an exception or a waiver of that restrictive covenant that you drafted. That's attacking your own work. Also, cross-examining a former client or someone who was a prior prospective client normally. Now, again, if the matters are too unrelated, it depends on the facts, but that could also be grounds for disqualification. Now, please note that the representation could be materially adverse to a former client, even if that former client or former prospective client is not even a party in the current matter. And the ABA gives some really nice examples from recent cases in the opinion that I'm going to talk about in a moment. But in a general category or type of case would be where you're attacking your prior work done for the former client as part of a new case, even if that former client isn't a party in the case. And again, this is going to depend on the facts. Now, even so, keep in mind that neither generalized financial harm nor claimed detriment that is not accompanied by demonstrable and material harm or risk of such harm to the former or prospective client's interests suffices. So just to focus on that for a moment and talk about this, the fact that your current client is a business rival of a former client. So the example I use in class sometimes will be two fast food restaurants, like two sandwich shops like Subway and Potbelly, or two burrito shops like Chipotle and Freebirds or Uberito. So your former client, if you formerly represented Chipotle, you can go ahead and represent Freebirds, even though your former client doesn't like them and doesn't want you to represent them and doesn't want you to help them in any way, help them succeed, because they think of the industry as in terms of market share and a zero-sum game. So any advantage to my competitor is a disadvantage to me. That does not constitute a conflict of interest. I have students ask me about this almost every semester, and that does not constitute a conflict of interest for purposes of the model rules normally. And so the former client merely being a business rival, or the fact that they could lose market share or something like that because you're helping their competitor, does not violate this rule and does not count as being materially adverse. Now, what about cross-examining? This is a minefield. Watch out for this. Please note that courts sometimes find material adverseness, what a terrible word, right? When a lawyer tries to examine a former client, even where the lawyer uses no information from the prior representation or the info is already generally known. So normally, if the information is generally known, that would be an exception under Rule 1.9, or you're not using the information. But sometimes courts, just from the fact that you are cross-examining a former client, they're worried that you know too much. You know how to push that person's buttons. You know how they respond to questions. You know certain matters that are going to make them agitated if you bring it up, and so forth. So you could be disqualified just because you are cross-examining a former client. Now, the ABA, one unusual thing or something that jumped out at me about this ethics opinion is their recommendation for this. They actually recommend hiring a separate lawyer and for the current client just for that task of that cross-examination of your former client, and then screening the lawyer, either whether it's you or others in your firm who have a conflict, previously represented the person that has to be examined. And that means no information sharing to prep for this or anything like that, or conversations about it. So the ABA is, I think, rather awkward solution, but still, this is a way to play it safe, is to tell your client, your current client, I'm likely to be disqualified if I have to cross-examine my former client or this person who came in for a consultation and shared extensive personal sensitive information. And so what we're going to do is we're going to hire another lawyer just for that task of doing the cross-examination. They're going to come in, they're going to cross-examine my former client. I will be screened from it, and therefore it eliminates the conflict and may save you from being disqualified from the case. Now, consent and waiver. Keep in mind that both of the rules we're talking about, 1.9 and 1.18, allow a lawyer to proceed with representing a current client against a former client or a prior prospective client if the lawyer obtains informed consent confirmed in writing. Also keep in mind that authorization to disclose or use confidential information is a separate question and will require separate consent. So the fact that a former client is willing to agree and say, I don't care if you are representing this person who has a material interest against me because our relationship, you represented me many years ago. Who is likely to waive conflicts of interest? I've given this example in class. That's very common. Is the big companies like insurance companies and banks that outsource lots of legal work, lots of litigation or real estate closings and foreclosures and things like that to a lot of different lawyers, and they know in turn that those lawyers are taking cases from lots of insurance companies or lots of banks, and so the in-house counsel at that insurance company or bank who's outsourcing litigation or foreclosures or closings to various firms in the area may not really care. They may expect this matter to settle quickly, or they're able to kind of do a quick risk analysis of the conflict and decide that it doesn't matter. So there, you can have waiver, but keep in mind, if you are going to use or disclose confidential information, that's a separate question, and you have to get independent authorization for that. The fact that they said, we don't care if you represent this person, does not mean that they've authorized the disclosure of confidential information. That's a tricky, rather fine point that I'm glad the ABA brought out. Okay, so here's a couple of fun examples. This is a 2014 case from the 8th Circuit, Zerger and Meyer versus the City of Greenwood. And I'm just going to tell you what happened. The city brought a nuisance action against a rock quarry, specifically over the noise and traffic from the big trucks that were hauling rocks out of the quarry or heading into the quarry to get loads and so forth. And part of the settlement was that the town or the city would get to designate the routes that these trucks would take going to and from the quarry. And there was a lawyer who represented the city in this matter and had obtained that as one of the conditions of the settlement. So sometime later, the same firm that had represented the city brought another nuisance action on behalf of the homeowners along the designated truck route against the same rock quarry. And so what do you think is going to happen? The city was not part of the new legal matter, the new litigation. So, and that's what I like about this example, is it's a nice example where a former client isn't a party to the new case against the other defendant, but they intervened and asked the court to disqualify the law firm that had represented them. Why? Because what the law firm is going to do, if the city, as part of the settlement, got to pick the route, and now the homeowners are saying, this is a nuisance that the trucks are going back and forth in front of our house every day, all day. Well, one outcome of this case could be to undermine the settlement that the same lawyer obtained for the city in the previous case, or to bring up alternate routes that could have been designated that the city didn't want for some reason, that might have produced less of a public nuisance. And so the court decided to disqualify the firm because the firm was advocating for a position that contradicted a term in the city's settlement, and the city had been the same firm's former client in that matter. Here's another example. This is a 1996 Texas case. This is National Medical Enterprises v. Godfrey. And this is about a hospital that got in a lot of trouble for mistreating patients and defrauding insurers. Or at least they were accused of that. So they were facing both criminal case prosecutions and civil cases. And the law firm that's in this case had represented one particular hospital administrator for this hospital. Now, this particular administrator had denied wrongdoing all along, had never been charged with a crime, and most of the civil cases against him had been dismissed. At some point, this firm and this hospital administrator had parted ways, and the firm withdrew from the representation. I don't know if they had a falling out or the representation ended, but they had withdrawn from the representation. And so now later, the same firm sued the same hospital on behalf of a large group of former patients. Now, that hospital administrator from who they previously represented was not part of the case, and in fact, this wasn't even patients from the hospital where that hospital administrator had worked. But the court disqualified the firm because adverse information about that hospital administrator was too likely to arise in the case when people started pointing their fingers and blaming each other and saying the problems were really because of this person, or things were even worse at this hospital over here, or why couldn't you have done things like you did at this hospital, and so forth, that it was too likely that one of the administrators who had been right in the middle of everything in the previous round of litigation was going to find himself in the middle of things again. And so the court disqualified the firm that had previously represented that individual. Now, we could talk about a counterexample, and this is a lawyer who represented a company who was a vendor that had a very lucrative contract actually with NASCAR. And this was a potential claim over a defective product. And a lawyer had represented the company in exploring this claim, but the company ultimately decided not to bring the case because they wanted to preserve this otherwise lucrative commercial relationship that they had with NASCAR. Now, the same lawyer later represented the retired founder of that company in a somewhat unrelated complaint against NASCAR. So same defendant, and an individual who was the retired founder had previously been associated with the company that had been the lawyer's client. And in this case, there was no disqualification, right? So there's no real conflict of interest just because this individual used to be intimately associated with the company that you represented, and it's a conflict between the party on the other side of the V, right, is the same defendant. The matters were unrelated, and there's no conflict of interest. Okay, that concludes our lecture about ABA Formal Ethics Opinion 497, which is about materially adverse conflicts with former clients and prior prospective clients.